How do I get a promissory note and related deed of trust assigned from the estate to me as an early distribution so I can manage payments intended for a minor beneficiary? In probate, the personal representative controls estate assets during administration, including a promissory note and the deed of trust that secures it. So you generally cannot just take over the loan on your own. If the estate is ready to distribute that asset in kind, the personal representative can transfer it by signing an assignment or endorsement of the promissory note, and a separate written assignment of the deed of trust. Then, the deed of trust assignment is recorded in the county land records where the property is located. Because the payments are intended for a minor beneficiary, the transfer usually has to be set up in a minor-safe, legally recognized way, like a transfer to a custodian under the Uniform Transfers to Minors Act, a transfer to a guardian, or delivery into the clerk's office, rather than informal control by an adult. A common approach is to propose a specific plan to the personal representative, including who will serve as custodian or guardian, how the note will be titled, and how the borrower will be told where to send payments. If the personal representative will not cooperate or is delaying, the next step is usually to file a request in the estate proceeding asking the clerk to direct or supervise the distribution and require the proper paperwork. Also, if you are using a Uniform Transfers to Minors Act custodianship and the total being transferred for the minor exceeds $10,000, or if the person making the transfer would also be the custodian, court authorization is typically required before the transfer can be completed.